Tonight we begin with a development that immigration attorneys, policy experts, and hundreds of thousands of skilled workers had feared, anticipated, and prepared for. A sweeping change that unfolded not over years of congressional debate, but in a matter of weeks. Weeks that will reshape the future of America's skilled workforce. Weeks that will determine whether hundreds of thousands of families can stay in the country they've called home. Weeks that will force employers to completely rethink their hiring strategies. What the Department of Homeland Security announced today crossed a line that advocacy groups had hoped would hold. And when that line broke, immigration attorneys and H-1B holders did not hesitate. They responded with urgency, precision, and growing alarm. If you hold an H-1B visa, if you're waiting for one, if your spouse depends on your status, or if your employer sponsors foreign workers, you need to watch this entire video. Because what's coming in 2026 changes everything. For months now, there had been signals, not official announcements, not formal press releases, just signals, that USCIS was preparing something unprecedented. The agency has been strict, yes, but they have been predictable in their strictness. Their policy changes have followed a certain rhythm, a pattern, almost a cadence that immigration lawyers could anticipate. But what set off alarm bells in Washington and Silicon Valley this quarter was that the pattern went silent. Insiders who monitor USCIS policy developments know the indicators. The quarterly stakeholder engagement meetings, the public comment periods on proposed rules, the gradual rollout of policy memoranda, the sudden increase in requests for evidence. All of that went quiet. And whenever USCIS goes quiet, it means something is about to get loud. For the past 18 months, the H-1B visa program has been under intense scrutiny. We've seen premium processing delays stretch to unprecedented lengths. We've seen denial rates fluctuate wildly depending on the service center. We've seen employers become increasingly nervous about sponsoring workers. But nothing prepared the immigration community for what was announced this week. The new H-1B regulations set to take effect in 2026 represent the most significant overhaul of the specialty occupation visa program since its creation in 1990. And the implications are staggering. Early Monday morning, the Department of Homeland Security released what they described as a comprehensive modernization of the H-1B visa program, including regulatory changes that had not been implemented in over 3 decades. These are the kinds of reforms that USCIS only announces when they are signaling something very specific: a complete restructuring of priorities, a fundamental shift in who qualifies, or a dramatic reduction in approvals. Immigration attorneys didn't know which category this fell into, or whether it fell into all 3 at once. But what they did know was that DHS was changing its posture on skilled immigration. And when a federal agency shifts policy direction without extensive public consultation, even by small measures, employers and visa holders pay attention. Here's what we now know about the 2026 H-1B changes. First, the lottery system is being completely overhauled. No longer will each registration receive an equal chance. Instead, USCIS will implement a wage-based selection system that prioritizes workers at higher salary levels. This means that entry-level positions, the very jobs that have traditionally brought young, talented graduates into the American workforce, will now face significantly lower odds of selection. Second, the definition of specialty occupation is being tightened dramatically. Under the new rules, USCIS will require a direct, specific match between the degree field and the job duties. General business degrees, liberal arts backgrounds, and interdisciplinary fields may no longer qualify. Third, and perhaps most concerning for current visa holders, the new regulations introduce enhanced scrutiny for visa extensions. Workers who have been in the country for years, who have built lives here, who have American-born children, they will now face the same level of review as first-time applicants. This is not a minor procedural update. This is a fundamental reshaping of America's skilled immigration system. The response issued by immigration advocacy groups tonight was not normal. It was not routine. It was not symbolic. It was urgent. Attorney after attorney, organization after organization described the new regulations as devastating, unprecedented, and perhaps most importantly, potentially illegal in their scope and implementation. But alarm only matters if it leads to action. The immigration community did not hesitate. In fact, their response today was among the most coordinated we've seen in the history of visa reform advocacy. Here's what we know. Within 48 hours of the announcement, the American Immigration Lawyers Association filed a formal objection to the rulemaking process. These weren't the standard comment letters. These were detailed legal challenges, arguments that USCIS had violated the Administrative Procedure Act by failing to provide adequate notice and comment periods. Major technology companies, including those that depend on H-1B workers for critical operations, have already begun lobbying efforts on Capitol Hill. University associations representing institutions that employ thousands of H-1B researchers have issued statements calling the changes a threat to American innovation, and grassroots organizations are mobilizing visa holders themselves, encouraging them to contact their congressional representatives, share their stories, and make their voices heard. The battle over these regulations has only just begun. Tonight, multiple sources confirmed that the 2026 regulations will fundamentally change the H-1B selection process, including the wage-based lottery system that had previously been proposed under the Trump administration but never fully implemented. Under the new system, USCIS will categorize all H-1B registrations into 4 wage levels. Level 1, entry-level positions at the 17th percentile of wages. Level 2, qualified positions at the 34th percentile. Level 3, experienced positions at the 50th percentile. Level 4, fully competent positions at the 67th percentile and above. The lottery will now prioritize Level 4 positions first. Only after all Level 4 registrations have been selected will Level 3 be considered, and so on down the chain. What this means in practice is devastating for younger workers and smaller companies. Entry-level software engineers at startups? Their odds of selection drop dramatically. Recent graduates with master's degrees from American universities, they may never make it through the lottery. Smaller companies that cannot afford to pay top-tier wages from day one, they will lose access to the global talent pool entirely. USCIS claims this change will ensure that the H-1B program serves the most skilled and highest-paid workers. But critics argue it will simply hand the entire program to large corporations while shutting out the innovative startups that have historically driven American economic growth. The specialty occupation changes are equally concerning. Under current rules, a worker with a general degree could qualify for an H-1B if they could demonstrate relevant experience or specialized training. Under the 2026 rules, that flexibility disappears. A computer science job will require a computer science degree. A financial analyst position will require a finance or accounting degree. Interdisciplinary backgrounds, the very combinations that often produce the most innovative thinkers, will no longer meet the standard. This is what makes the new regulations so concerning. They don't just change the numbers, they change the fundamental nature of who can participate in America's skilled workforce. And here's where the story becomes even more troubling. Policy analysts now believe that DHS's latest move was designed to test the response of industry and advocacy groups after years of incremental restrictions. The administration wanted to see whether employers would simply accept the changes as the new normal. But instead, the opposite happened. Companies didn't quietly comply. They launched a coordinated response that was so swift, so unified, that even Washington noticed. You don't get the attention of federal policymakers easily. But today, the tech industry and immigration advocates did exactly that. Immigration experts speaking with major news outlets under anonymity described the regulatory shift as policy by attrition, a way to reduce immigration numbers without formal legislative action. But advocates proved today that they remain both organized and determined. Their legal challenges were not only comprehensive, they were filed so quickly that USCIS may be forced to delay implementation. That timing matters because it shows coordination across multiple organizations. It shows that the immigration community is not a passive observer. They are active participants in shaping policy. And they are not going away quietly. What happens over the next 12 months will determine whether these regulations survive legal challenge or whether they become another failed attempt to fundamentally reshape American immigration policy through executive action alone. As reports continued coming in throughout the week, we learned more about the scale of the impact. Major technology companies reported that up to 40% of their technical workforce could be affected by the specialty occupation changes. Universities announced that thousands of research positions currently held by H-1B workers may become impossible to fill under the new definitions. Healthcare organizations warned that the changes could worsen existing physician shortages in rural and underserved areas. This wasn't just about Silicon Valley. This wasn't just about tech workers. This was about the entire American innovation economy. This was about research institutions, hospitals, financial firms, manufacturing companies, and thousands of small businesses that depend on global talent. And global talent is the one thing America has struggled to retain since the COVID-19 pandemic disrupted international mobility. For every restriction the U.S. has implemented, Canada, Australia, and the United Kingdom have countered with policies that make their countries more attractive to skilled workers. The competition for talent has never been more intense, and these regulations may push America further behind in that race. Remember, proponents of the H-1B program believed it would strengthen American competitiveness. They believed that attracting the world's best and brightest would drive innovation. They believed that skilled immigration was a net positive for the American economy. But tonight, the opposite philosophy is being codified into regulation. The assumption now is that foreign workers take jobs from Americans. The assumption is that wages are suppressed by skilled immigration. The assumption is that restricting the program will somehow benefit the American worker. Economists disagree. Study after study has shown that H-1B workers complement rather than replace American workers. They start companies at higher rates than native-born citizens. They file patents, publish research, and create jobs. But those facts seem to matter less than the political narrative that immigration must be restricted. What makes this moment so critical and so uncertain is that these regulations arrived at a time when both political parties are under pressure from competing interests. Business leaders want access to global talent. Labor unions want protections for American workers. Immigration advocates want a pathway to permanent residency, and restrictionist groups want lower overall immigration numbers. Policymakers are balancing these demands while facing an election cycle where immigration has become one of the most divisive issues in American politics. And when regulators in that position make sudden moves, they're not always doing it from sound policy analysis. They're doing it from political pressure. They're doing it from electoral calculations. The workers caught in the middle, the hundreds of thousands of professionals who have built lives in America on H-1B visas, are watching to see whether their futures matter in this equation. DHS's official statement, now circulating across every immigration news platform, was designed to signal that the administration is committed to what they call protecting American workers. Officials said plainly that the current H-1B system was inconsistent with the program's original intent. That is bureaucratic language for, "We believe the program has been abused and we're fixing it." You don't usually hear that tone from DHS unless they are prepared for a legal battle. And a legal battle is exactly what they're going to get. Multiple lawsuits are already being prepared. The coming months will determine whether courts agree that these changes followed proper procedures, or whether USCIS overstepped its authority. Meanwhile, the president of the American Immigration Lawyers Association addressed members in an emergency broadcast tonight. She said, "These regulations represent a fundamental threat to the H-1B program as we know it." She said, "Our clients are not statistics. They are people who have contributed to this country for years, sometimes decades." And she said, "We will use every legal tool available to challenge these changes." These are not rhetorical flourishes. These are statements from an organization that understands just how high the stakes have become. Here's what makes the situation even more concerning. The H-1B changes weren't isolated. Along with the wage-based lottery and specialty occupation restrictions, USCIS also announced increased fees for visa applications, some rising by over 50%. The Department of State implemented new interview requirements for visa renewals. And DOL increased its scrutiny of labor condition applications, adding weeks to processing times. All of this happened within the same quarter. When the government moves multiple pieces at once, it means something larger is underway. This appears to be a coordinated effort to restrict skilled immigration across multiple agencies simultaneously. Immigration analysts are now considering several possibilities. One is that these regulations are designed to reduce H-1B numbers without congressional action. Another is that the administration is attempting to shift the H-1B program toward higher-paid workers exclusively. A third possibility, the one worrying employers the most, is that these changes are just the first phase of a broader effort to fundamentally restrict employment-based immigration entirely. But today, advocacy groups took that uncertainty off the table. They didn't wait for implementation. They didn't accept the changes quietly. They didn't hope for the best without taking action. They organized, filed legal challenges, and mobilized stakeholders across the country. What we're watching now is a test of America's commitment to skilled immigration. USCIS wants to see whether these changes will survive legal scrutiny and public pressure. Employers want to show that the current system serves American economic interests. Courts want to ensure that proper regulatory procedures were followed. And H-1B workers want to know whether they have a future in the country they've chosen to call home. Tonight, we've heard from immigration attorneys who are now advising clients on immediate next steps. They say anyone with a pending H-1B case should ensure their documentation is as strong as possible. They say workers approaching their 6-year limit should expedite any green card applications currently in process. And they say the decision to implement these changes in 2026 provides a narrow window for current visa holders to secure their status before the new rules take effect. But advocates are not conceding defeat. In fact, they are preparing for a sustained legal and political battle. Their response today, swift, coordinated, and determined, sent a message to USCIS that these changes will not go unchallenged. And it sent a message to H-1B workers that they are not alone in this fight. As the coming months unfold, we expect more details to emerge about the implementation timeline and potential exemptions. But what we do know is that the response from the immigration community was immediate. It signaled to policymakers that stakeholders are watching. It demonstrated that legal challenges are coming. And it gave hope to hundreds of thousands of workers who feared they had been forgotten. What happens next will depend on what courts and Congress do in the next year. If the regulations survive legal challenge, 2026 will be remembered as the year America fundamentally changed its approach to skilled immigration. If courts strike them down, USCIS will be forced back to the drawing board, and advocates will have won crucial time. Either way, H-1B holders have already shown they are prepared to fight for their futures. They have shown they are ready to respond. And tonight, for the first time in years, the future of America's skilled immigration system appears to be genuinely uncertain. Washington is watching. Silicon Valley is watching. And hundreds of thousands of H-1B workers are watching most closely of all. Because tonight, they learned something they may have already suspected. Their future in America is not guaranteed. Their contributions are not universally valued. And their fight is only beginning. This story is far from over. But tonight, one thing is clear. The H-1B program as we knew it is changing. The workers who depend on it are mobilizing. And the next 12 months will determine whether America remains a destination for the world's best talent or whether that era has come to an end. And we will be here, watching every detail as the next phase unfolds.